is on trial yet again. Governor Rick Scott signing some changes to it last month, but a judge in Miami said the governor did not actually have a right to do that, ruling those changes unconstitutional. So what does it all mean for you? We have our good friend and defense attorney Bob Fisher here this morning to talk more about it. Good to see you, Bob. How are you?
I'm doing well. Thanks for having me.
All right, so let's talk first about what the changes are. So the law has been changed to put the preponderance of the evidence, or whoever has to prove the case, on which side?
Well, the law used to be, when it was enacted back in 2005, that the defense had the burden of proof to show by a preponderance of the evidence, a tip of the scales, 50% plus one, they were entitled to the immunity provided by the statute. The new law enacted a month or two ago changes the burden from the defense to the government, and it increases the burden from a preponderance to clear and convincing evidence.
Okay. All right, so when they say the governor does not have the right to do that, how do you weigh in on that?
Well, I happen to know the judge that wrote this opinion. He's a brilliant man. He teaches every year at the annual meeting of the Florida Association of Criminal Defense Lawyers. He's not an attention seeker. He's a very, very smart guy, and he's a well-reasoned opinion. It's 14 pages in length, Amy. The bottom line is this. The legislature is responsible for enacting or making laws, the substance. The Supreme Court then directs or dictates the method by which that substantive law is utilized in a courtroom. So it's substance legislature, procedures Supreme Court. Judge Hirsch's opinion says this is an overreaching branch of government, that the legislature didn't have the right to change procedure the way they did.
So what happens now, Bob?
I believe, because of the well-reasoning of the opinion, that the Florida Supreme Court is going to agree with Judge Hirsch and hold that the statute as it's written is unconstitutional because of the procedural change.
Okay, so then do we go back to it rests back on the defense attorney's shoulders?
Yes, based upon that ruling, if it's upheld by the Supreme Court that the current statute is unconstitutional because of an overreaching branch of government, then we will revert back to the law that existed since 2005, where the defense has the burden of proof.
All right, it is interesting to watch, and obviously the story is not over, so Bob will be bringing you back to explain the rest of it. Thank you. Always good to see you, my friend.
Stay tuned.
All right, take care.